Hi, I'm Val Schober, and this is my presentation on tort liability. What is tort liability? According to our textbook, A Teacher's Pocket Guide to School Law, it is defined as an actionable or civil wrong committed against one person by another that is independent of contract. So what this tells us is that schools are liable for liability charges. They may involve neglect if an injury occurs at school, during a school function, before or after school. It can also occur when a child's reputation was injured. In schools, tort law may involve class action suits that can affect a number of people, which means teachers, administration, and school board. According to our book, teachers by law have the responsibility to instruct students, supervise students, and provide safety for all students. There are two categories with tort liability: intentional torts and unintentional torts. Intentional torts include such things as assault, battery, slander, trespass to personal property, and defamation. Unintentional torts can include invasion of privacy, negligent, and breach of duty, which fails to meet when teachers fail to meet their duty of care. So this is the first case that I looked at, Arnett versus Caldwell. In this situation, a teacher had left the classroom to use the restroom, and she left the classroom unattended. Two students engaged in horseplay. One student fell on top of the other student, which caused a laceration of a major blood vessel by a dislocated collarbone. The EMT took the child to the hospital, and the child was later pronounced dead. The teacher of the child sued the parents for wrongful death, saying that the teacher was negligent in the supervision of the students due to leaving the room. The trial court then was in favor of the teacher leaving the classroom and called this a discretionary act. And what this is an act involving personal judgment. So the teacher used her own personal judgment to leave the classroom, thinking that the classroom would be safe. Then this entitled her to what they call official immunity, which is that public officials are not liable for injuries to others as long as that official was exerting official authority. So in this case, her authority was her discretionary act of being able to leave the room and not in the kids being safe. As far as evaluating this situation and taking if this would happen at my school, because I am with infants and toddlers and with preschool age students, we do not ever leave the classroom unattended for any reason. There are also paras and different support staff that are in and out of the classrooms at all times, so we can call on and utilize those people if a teacher needs to leave the classroom. So as far as this happening at our school, it would be very, very rare that a classroom would be left unattended. In fact, it just wouldn't happen. It cannot happen for preschool age students. So how do we prevent this is we have already set up a system in our school that if a teacher needs to leave a classroom, she can call the office, where the office then coordinates with other staff to make sure that there is staff, paras, administration, somebody in the classroom supervising the children as the teacher leaves the classroom. The next case that I looked at was Coffee County School District versus Snipes. And in this situation, the children were at recess, and during recess, a child fell and fractured her elbow. The parents sued the school district, the teacher, and para due to they did not feel like the student was supervised adequately during recess. The superintendent in the situation supported the teacher and the para and stated that at this time that there were no written rules or regulations pertaining to supervision of recess activities, and it was left up to the discretion of the staff to do what they thought was best as far as supervising students. And since the staff were performing what they thought was appropriate when the fall occurred, they are immune from personal liability. And so the school district and the teacher and the para were entitled to official immunity according to the courts. As far as evaluating in this situation, again, because we are a preschool and have small children, the staff is supposed to be eyes on at all times with the students. We also do not have a specific recess policy in place other than staff need to be eyes open watching the parent or watching the students, and that at least two people are out in the playground at all time. So that's pretty as specific as we get. So as far as other proactive measures that I would take is just to make sure that the staff is not distracted at any time during the playground. I know cell phones are a big issue right now, and just making sure that all staff are not distracted by cell phones or anything else going on while the children are at recess, so that that can not only for safety of the children, but to protect the staff. The next case that I looked at was Sutton versus Douglas. And in this situation, a parent sued a PE teacher and the school board after her son was injured in an automobile accident. So in this situation, the school was dismissed at 11 o'clock due to they have a policy that the day that grade cards go out, that they have a half day of school. So that allows parents to come and pick up their grade cards. In this situation, the child was not picked up from school. So the teacher brought the student into the office where they tried to get a hold of the parent to come pick up the child. The child was left in the school and saw a parent that he knew and knew that was his neighbor and followed them and left the office, followed them and walked home with them or kind of behind them. As soon as the parent realized that the student was there, she brought the student back to the school. As the student got out of the car to go into the school, the child ran into the side of another car, which was the PE teacher. So in this case, the judge ruled, as goes with medical expenses and the liability of the medical expenses, the judge ruled that 60% of the negligence was on the parent. The parent was at home and should have known that school got out at 11 o'clock. And then 40% of the medical expenses were, the judge ruled, negligence of the school board, saying that the staff should have known that the child was in the office and should have been supervising the child in the office better. As far as kind of if this kind of thing happened at our school, we also have a policy that if kids are not picked up from preschool, they're brought to the office where the office staff and another para is in charge of watching the child until parents or guardian or somebody comes and picks up the child. And then the same goes for on the bus. So if a child is riding home on the bus and the parent is to meet the child at the bus, and if a child is, or the parent does not meet the child at the bus brings the child back to the school where they notify the parents and is left in the office. So we have multiple people. Administration is also part of this to make sure that if children are not picked up right after school, or the school bus has to bring them back, that there are people there to watch the child and supervise the child. So this would kind of, so my reaction to this is that they just needed to also have this, the people in the office needed to know that the child was there and that the child left. Although I know children that are young can run off real easily, you still just have to keep all eyes on these kiddos. So yes, so we do have a policy at our school for those kids that are left. And I'm sure this did too. It just sounded like maybe the child ran out and the office staff did not know that. So just to make sure the office staff or whoever is in charge of watching these children as they have not been picked up to school need to make sure that they are not make sure that they are supervising the children adequately. The next one I looked at was Johnson Johnson versus the school district of Millard. And in this case, it was a first grader that was injured during music class. The teacher taught the children the dance and song to London Bridge, which is kids taking arms and one child then going across the arms. The teacher did give specific rules to the students as to not be silly, do not yell, scream, or swing their arms too much. And then she allowed the children to play the game on their own. And during this time, the child was released a little too hard and fell into a bookshelf. And there got stitches in his head. And the child claims that he told the other kids to stop swinging him and that he tried yelling over the music, but it was too loud. So the court in this case said that the teacher did not adequately supervise the children and was then therefore negligent in the supervision of this child as to why the child got injured. So the court awarded the Johnson family money for medical expenses, pain and suffering, and permanent disfigurement. So as far as if this would happen in my school or kind of reactive measures to this is that I think this being the first time that they did this activity, the teacher needed to be all eyes on and supervising it and maybe doing it a little differently, as if it's a big class, things can get out of hand. Maybe taking turns or adding additional support in the classroom if they're kind of doing an activity that has a little bit more action and could cause some injuries, which I mean there's a lot of activities that can cause injuries. So proactive measures I would say is that the teacher, since this was the first time that these children had done this activity, she needed to make sure that she was not distracted by anything else and supervise the kids making rounds and making sure all the kids were doing this appropriate, because if this child was trying to get help, the teacher must have been distracted so that she did not have eyes on the child that needed some help and to get out of the situation. The last case that I looked at was NM versus the Anchorage School District. In this situation, a 6-year-old child falls while running to his mom. It was the end of the day. The child was excited, went running to his mom, and during this time, the child fell, tripped, and landed on a stump clump of pine shrubs so that there were tree stumps that were out that the child fell on. One stick penetrated the child's eye socket and jabbing the frontal lobe of his brain, so he had a pretty serious injury. Parents claim that the school district was negligent in allowing the stumps to remain on the path of that is trafficked by small children. The court also favored that the school district was negligent. The child did suffer some brain damage, also developed narcolepsy, so had some lifelong things that happened due to this incident. So according to this, the family was awarded $4.5 million in damages to include emotional distress suffered by parents and medical expenses. So this was kind of a tough case for me to read because this kind of accident could happen, I mean, anywhere, and it's just a real sad one. Well, there's many that were sad actually, but so in this situation, I think it's very important as you look at reactive measures that there should not have been any stumps in the yard. In the front side, you have to make sure that the school is a safe place and kids can run. There are still accidents that will happen, but these kinds of things can be avoided if, say in this situation, the stumps were not there, because kids don't look, they just kind of run. So falling on stumps could have been avoided if the stumps were not there. So looking at kind of professional ethics, I did like at the end of the article, Tort Liability 101, when are teachers liable? These kind of things came in mind at the back of that article. And I think as far as professional ethics, common sense and good judgment as teachers and administration and staff in schools, and going back to keeping kids safe, making sure that you're teaching and keeping a good, safe environment is, common sense and good judgment for any good teacher or administration. And utilizing those things are just pretty good, hard professional ethics that I have, and I want all of my staff to have as a future administrator. And I also liked these 6 points as teachers to kind of keep yourself out of the risk of liability or negligent or injuries. Is to perform your duties, do the duties and things that you're responsible for a teacher. Don't do things that you're not supposed to be doing. Don't elaborate from your duties. Do the things that you're supposed to be doing. Number 2, provide appropriate instruction, and that is appropriate instruction to your students and all staff involved. Paras, support staff, anybody that's involved in the classroom, in the activity, in anything to do. Make sure that everybody understands the appropriate instructions. Follow school rules, don't make up your own, which kind of also go along with number 1, so that you are following the rules that your school board has set up for you, and don't leer off of that, because then that you are more subject to liability charges due to that. So if you stay with those things, it kind of the school will help and support you in most cases. 4, keep private information private. One thing that they did talk about in the book is don't talk about students, don't talk about other staff or any types of situations with any other people. Make sure that everything that it kind of goes with that confidentiality. Make sure everything is confidential, safe, and private. Document any student incidents that occur in your classroom or that you witness, and document any concerns that you have addressed with administration. That kind of just helps you out so that you have that documentation. And 6, always do what is best for the student. If you do not think it is best for students, you probably should not be doing it. And these are all my references, including a few of the articles and the cases that I looked at. So thank you.